Okay, let's take a look at question 1 from 2012, February. It's a wills and trust essay, and it's predominantly trust with a little bit of a wills issue. Again, this is meant for trust, and the reason why it's not standing on its own is because trust essays are not easy to come by when they're standalone. They're usually crossed over with wills, occasionally community property or PR, but very rarely do trust essays appear on their own. Okay, if you haven't read the fact pattern, pause the recording right now and go ahead and read the fact pattern 2 or 3 times so that you can follow the discussion better. Everything we do in the video, everything we do in class, everything on the audios, it's the exact way I want you to do it on the bar exam. Nothing changes. You practice the way you play, so let's practice it the right way. Okay, number 1. What interests, if any, does Dave have in the trust assets? Notice it said, answer according to California law. Why are the examiners saying answer according to California law there and not at the end? And why is it not in calls 2 and 3? And the answer is, this is the wills portion of the essay. So call number 1, Dave, interest in the trust assets. That is the wills. Okay? Number 2. Are Beth and Carol likely to be successful in terminating the trust? Okay, well, since we know this is not California specific, this turns out to be the trust issues. And we know how to terminate a trust. How do you modify or terminate a trust? Well, it's consent of settlor and all beneficiaries. All beneficiaries agree. Express terms. Settlor reserves power to revoke. Trustee is instructed. Okay, that's the only way to modify or terminate a trust, so that's got to be the way. That's got to be what's going on there. And number 3, are Carol and Beth and Carol likely to be successful in suing Tara? Let me guess. Tara is the trustee, so it probably has to do with the breach of the trustee's duties. So for number 3, B and C versus trustee. Okay. So, again, this is why we go to the call to question first. This is wills, because wills is a California-specific subject, so is community property. Trust is not. You answer trust according to general principles. That's why the examiners are saying answer according to California law number 1 and not number 2 and 3. But you see just how clearly this starts to play out just by the call to question. Talking about modifying a trust or terminating a trust, well, there's an entire section of the trust outline. There's only 4 sections of the trust outline. Creation, trustee's duties, the different types of trust, and the modification and termination. Well, here, modification and termination, there's only a certain number of ways to terminate a trust, which are all common sense ways. Settlor and the beneficiaries all agree. Or if the settlor's dead, all the beneficiaries agree unless a material purpose remains. The express terms, or where the trustee is given the ability and the power to go ahead and revoke the trust or cancel the trust for whatever reason, or if the settlor reserves the power, if it's not an irrevocable trust, which means it's going to be a revocable trust. So there you go. Okay, that's what we have going on. Now we can attack the essay knowing full well what we're doing. Sam, a widower. Why are they telling us he's a widower? You will see this, it'll happen almost every time when the examiners don't want you to discuss community property. Now, sometimes they'll have a widower get married later on. Well, obviously, that changes the fact pattern. But when they say a widower, they're trying to say no community property issues. Set up a valid, revocable, inter vivos trust. So it's valid, which means the creation of a trust. The examiners have already gone out of their way and said, okay, the trust, we already know the trust is being created. We don't need to go into formation issues. So they completely eliminate that. So don't waste your time going to the creation of a trust. And it says it's revocable, which means if the trust is revocable, Sam can revoke it. However, if the express term said he can revoke it, however it says he can revoke it, it's revocable depending on how Sam set it up. And inter vivos means during life, which means Sam's not dead yet. So it's not a testamentary trust, it's a valid inter vivos during life trust. Naming himself as trustee, and he can do that. And because it's a revocable trust, even though it's not relevant on these facts, just remember the creditors can reach it because he has not given up his power to control the property. He still technically owns the property. Now with an irrevocable trust, you've given it away. And if you're not a beneficiary of an irrevocable trust, that money's gone. So that's why the creditors can't reach it. And providing that upon his death or incapacity, his cousin Tara should be successor trustee. Okay, that's fine. Don't forget, she doesn't have to accept the appointment. You don't have to serve as trustee. You get paid to serve as trustee, but you get a lot of duties attached to it. Most regular people will decline being a trustee. I wouldn't be a trustee for the estate. There's no point. I'd rather have some professional do it. I don't need the hassle. I don't have enough experience to do so. Anyways, that's a side note. He did not name any additional trustee, and it's okay because a trust will not fail for lack of a trustee. The court will just simply appoint one. He directed the trustee to distribute the income from the trust annually in equal shares to his 3 children. Those are the express terms. And the express terms say equally to all 3 children. Simple as that. And that means the trustee is not given discretion on who to give the money to. It says give it to all 3 of them equally. It's not too hard to follow the directions. So a trustee must administer the trust according to its terms. That means the trustee must follow the directions that the settlor has provided. He specified that at the death of the last of the 3 named children, so after A, B, and C all pass away, the trust was to terminate. So the trust is terminating by express terms. And the remaining assets were to be distributed to his then living descendants by representation. So living descendants means everybody everybody down the line. So his children, his grandchildren, and so forth. When he established the trust, so there really isn't much in the first paragraph, but just a lot of background information and stuff that sets up later. When he established the trust, he also executed a valid will pouring over all his additional assets into the trust. That means whatever's left in the residue, generally what's going to be left in the residue of the estate, in the will, is going to go into the trust. So all the assets not disposed of specifically by the will end up going into the trust and will become part of the trust property. And there's really nothing more to that than what it is. So it's a pour over will. Okay, 2 years later, Sam died. Now Sam's dead, and this is when everything starts kicking into gear. He was survived by A, B, and C. Within 2 months, Dave, age 25, began litigation to prove that he was also a child of Sam's, although Sam had never known of his existence. Okay, there's the wills issue. So, what do we have? The biggest and most heavily tested issue in wills is omitted child or unknown child. Well, omitted child really has to do with when you unintentionally omit somebody. Within the same vein, but it's a different statute, believe it or not, there's the unknown child. So an omitted child is when you unintentionally you forget to include your child into your estate. So if I'm married, my wife, and I have a will, and then 2 years later I end up having a child, and then 3 years later I end up dying without amending my will, that's an omitted child. An unknown child is a situation like this. Like every guy out there, believe it or not, you can actually have a child without you knowing it. And we all share that fear. I know I do. Last thing I want to do is somebody, daddy. Okay, so unknown child. An unknown child, if you can prove it, that this actually is your child, which is going to be proved through DNA, clear and convincing evidence, not important for bar exam purposes, but in real life. So the unknown child will get their intestate share. And because we know there's 3 children, he's going to get 1/4 or 25%. That's how it's going to work out. So that's the only will issue. That's why we're doing this essay, because it's predominantly trust. The only will issue is the unknown child. Unknown child takes intestacy, because the legislature presumes that if you knew that child existed, you would have wanted to provide for the child. Of course, you can always write a will that says, I hereby disinherit any child unknown or otherwise a lie that could be mine, and I specifically devise the property to these people who I know. You can do that. But without a will, without specific directions, you're going to get intestate share for the unknown child. So that's all that's going on there. For 3 years after Sam's death, the trustee, Tara, administered the trust as trustee. Because Anne had very serious medical problems and could not work. Don't forget, Anne, Beth, and Carol are the 3 children that are supposed to get the income equally. And because Beth and Carol had sufficient assets of their own, Tara, the trustee, distributed nearly all the trust income to Anne and little to Beth and Carl. Well, we have, the express terms say, no, you have to give it equally. So she's not doing it equally, so she's not acting impartially by favoring one beneficiary over the other. I mean, think about it. Yeah, you might see to yourself, okay, that's all, fair, but I'll tell you this much. Maybe my brothers, I have 2 brothers, and if they're not doing as well as me, I don't want the trustee to unilaterally decide, hey, let's give the money to my little brother who decides to live off of Uncle Sucker and not work. So, hypothetically, of course. So the duty act impartially, the trustee does not have the discretion to decide who to start dishing out the money to unless it's a discretionary trust, which it's clearly not. So they're not acting impartially, which also violates the duty of care. Because the duty of care is kind of the overall breaching of the reasonable care, skill, and prudence and caution as you would with your own money. And if Sam told the trustee to do a certain thing, the trustee has to follow suit because you have to follow the settler's intent. That's the whole point of it. So what are the remedies for this? For the breach of the trust? Well, pay damages. B and C could affirm the transaction and approve it. I don't think they're going to ratify it because they're the ones suing the trustee. Then you have, you remove the trustee, set aside the transaction, which isn't appropriate on these facts, or disgorge any profits, which isn't, again, not relevant on these facts. Okay. Disgorge profits. All right, moving on. So we have pretty much what they're going to do is pay damages and have them removed as a trustee. Those are the remedies that are relevant here. Because the express terms say do it equally, did not act impartially because they're favoring A, because she's sick or whatever her deal is, breach the duty of care, pay damages, and remove. There we go. So pretty much, believe it or not, we're actually done. Everything's already filled in. And that's how simple this stuff can be when you actually take your time to read it. We're less than 10 minutes in, and we've already solved the thing. We know exactly what we're discussing. Okay, moving on. Again, Tara distributed nearly all the income to Anne, little of Beth and Carl. After the court determined that Dave was in fact Sam's child, Dave claimed his share of the trust. Well, he'll get his intestate share. Beth and Carol have filed suit against Tara, claiming breach of fiduciary duties. Duty to act impartially, duty of care, in express terms. Now, don't forget, there's no investing, so we don't have to go into the prudent investing rule. We're not going to have to go into duty to diversify because there's no investing going on. It's just simply paying out the assets, not following the express terms. So there's no reason to go into any of those specific duties. Tara has submitted her resignation, which is fine. She's going to be removed anyway, so it's a good thing that she's sending in her resignation. She'll probably be removed by the court. And Beth and Carol have sought termination of the trust so that all assets may now be distributed outright to the beneficiaries now living. Well, let's look at the terms of the trust. It went to A, B, and C, and then at their death, their remaining assets were to be distributed to his living descendants by representation. So the class is going to close, obviously, when A, B, and C die, and we'll know who's left. Okay, so do we have the consent of the settler and all beneficiaries? No, because the settler's dead. Do the express terms say when it's going to terminate, but we haven't reached that point yet, so they're trying to terminate it without the express terms, so that doesn't apply. Doesn't apply here. The settler didn't reserve the power to revoke, and the trustee isn't instructed, like the trustee can't unilaterally just decide to do it, and the trustee's not trying to do. So it's like, do all the beneficiaries agree? The answer is no. I don't see Anne joining in on this because Anne's not doing it. Also, we don't know who the living descendants are, so you probably need a representative from that class to join in, which they're not. So just because B and C want to do it, they're not going to be able to terminate the trust by themselves. They need A, and they need whoever the living descendants might be. I don't even know if you could close it in those situations. Nevertheless, it's irrelevant, at least for this discussion, for what the examiners, because that goes way too deep into what the examiners expect from you. It's just that cannot terminate it because not all the beneficiaries agree. And there's also probably material purpose left because they want to provide for the living descendants, whoever those might be. So they're not even included in this. Again, you're not going to be able to modify or terminate it. All right. So again, number one, what interest, if any, does Dave have in the estate? Dave is a known child because Sam was not aware of his birth. Because Sam wasn't aware of his birth, takes the intestate share, which would be 1/4 or 25% of the estate. In terms of the termination, it's not going to be by the consent of the settlor and all beneficiaries. Only Beth and Carol have joined in this. Anne hasn't joined in, neither the living descendants, because that group has not yet been defined and is still subject to adding more class members, so it would be pretty difficult for them to terminate it based on that. The directions do not give Tara the power to unilaterally revoke the trust, and Sam did not reserve the right to revoke it. It became irrevocable once Sam died, and the terms are when everyone dies and people are still alive, so they're going to try it, so they're not going to be able to terminate it prematurely. And finally, the breach of the duties. The duty to, a trustee has a duty to administer the trust according to its term. That means just to follow the instructions of the trust. And the instructions said to pay all the children equally. Tara was not authorized to favor Anne to the detriment of Beth and Carl, so she's not acting impartially. Breach of the duty of care. And again, the remedies are pay damages and remove will be the two appropriate remedies under these facts. And that's it. Believe it or not, this is actually a longer fact pattern, which contained a little bit of background information and not a lot of things that were directly relevant. But it was a pretty simple essay. They tested very common issues. Omitted child, unknown child, very heavily tested in wills. In fact, it's the most heavily tested issue. Trustees' duties are, again, up on the top list of there's only very few issues that are tested in trust. This is really heavily tested. And modification, termination, it's occasionally tested here and there. So there you go. There's a wrap for the 2012 February question 1 Wills and Trust essay. Thanks a lot.